Number 293, Robert Eli Stanley versus Georgia. No, and my son was up by saying that's a hell of a way to run a railroad.
May it please the court, I would like to request the marshal to notify me when 25 minutes is up. I'd like to save 5 minutes for rebuttal if I may.
You'll find a white light come up in front of you. That will be the 5-minute warning.
Thank you.
Mr. Asanoff, you may proceed with your argument.
Thank you. Mr. Chief Justice and members of the court, this case involves the constitutionality of the Georgia obscenity statute. The questions raised by this appeal, insofar as the constitutionality of the statute are concerned, are twofold. First, we raise the question that the statute violates the First Amendment because it punishes the mere possession of obscene material without requiring any further overt act on the part of the possessor or intent to do anything with it.
What kind of possession was this?
This was a possession, if you ought to please, where Robert Eli Stanley had possession of 3 reels of motion picture film in a desk drawer of his upstairs bedroom of his home. There was no allegation in the indictment of any showing or attempt to exhibit or show these films or pander them or show them to minors. The only question involved insofar as the indictment was concerned was that he possessed them knowing them to have been obscene, or that he should reasonably have known them to have been obscene. The second question of our constitutional attack on this statute is the use of the language in the statute and in the indictment to the effect that he reasonably should have known of the obscene nature of the film removes the element of scienter from the definition of the offense, and thus permits the state to secure a conviction for possessing these films on a showing less than actual knowledge on his part that they were obscene.
Are they conceitedly obscene?
We do not concede them to be obscene, and we took that position with the trial court that under the First Amendment, insofar as possession itself is concerned, that there is no such thing as obscenity. The reason we took that position and now take this position is this: that it would be a violation of the freedom of press clause of the First Amendment to restrict a person or to prohibit a person from possessing anything they want insofar as its claim of obscenity is concerned. We take the position that where a person merely possesses an article alleged to be obscene and does not attempt to distribute it or show it to any other persons, as was the case in this case and as was the indictment in this case, and as was the holding by the Supreme Court that the mere possession is an offense under the definition of Georgia law, that any evidence in the case on the part of the state or any contention on the part of the state to the effect that the evidence might have circumstantially shown that he was about to have a party and about to show these films to other persons would be completely irrelevant for this court to consider. It has no relevancy here because of the fact that he was only charged with the mere possession. Now, to my knowledge, this exact question has never been passed upon by this court. The question of whether or not a person can be prohibited by the states from merely possessing obscene material or obscene writings or pictures. Clearly, it would seem to me that the mere possession, and anyone would have the right to, say, draw a picture which might obviously be obscene to some other person and put it in his pocket or put it in his desk drawer. Or if he wanted to take a picture of himself or a picture of himself and his wife in a sexual act, that this would be a matter that he could determine as long as he did not attempt to pander this material, attempt to sell it, distribute it, or distribute it to minors.
I suppose when these films were in a desk drawer.
These films were in a desk drawer. This, of course, is the...
Of course, you couldn't just, looking at the film, couldn't tell what it was.
Could not.
Now, what did the officers do?
The officers, and this is, I might as well mention this at the outset right here. The second part of our contention is the officers were armed, they were federal and state officers, were armed with a federal search warrant issued by a United States Commissioner on a claim that the defendant was violating the Wagering Tax Act.
What?
The Wagering Tax Act. Since then, of course, this court has held that the provisions of that law are constitutionally impermissible.
Well, I'm trying to get to it. Did the officers use the projector to see the film?
Yes, yes. This
then
is,
and there?
yes, sir. Then and there. They went in armed with the search warrant issued by a United States Commissioner, which did not call for the seizure of any obscene films, but called for the seizure of gambling paraphernalia. No gambling paraphernalia was seized except some negligible things that I think the state concedes were not sufficient. But during their search, they searched through this drawer and found 3 cans of film, 8mm film, which they testified they could not discern or know from their own knowledge that it was or what it was. So they found in the closet a projector, and they found a screen. And they showed these films and looked at them, and after
They set up the screen and set up...
then they set up the screen and they showed them.
Is there any conceivable circumstance in which, if you saw a film, that could it possibly be connected with gambling paraphernalia?
I would think not. I would think not. I wouldn't know that there was any connection between them. But what happened after they showed these films, not having a warrant to seize the films, the evidence shows in the case and in the record that the officer, the state officer, called the Solicitor General, who is the prosecuting officer for that circuit, and told him they didn't find gambling paraphernalia, but that they did find some films. And it's in the record that the Solicitor General then stated to him, after you view the films, if in your opinion they are obscene, seize the films and book a case and I'll set a bond.
Well, tell me, suppose instead of these films, they'd found counterfeit bills. Could this fellow have been prosecuted for possession of counterfeit?
I think so.
Yeah. How do you distinguish that?
I distinguish that, and I concede that where evidence is seized or where contraband is seized, where it's not such as would be subject to a claim of the First Amendment, freedom of press or freedom of speech, that the states do have the right to prohibit the possession.
I take it Harris would
Yes,
require that as
yes.
counterfeit money, wouldn't he?
Yes, I think any case, and we can see that in our brief and make that distinction, that in this particular case, these were films alleged to be obscene from the very start. They weren't seized as gambling paraphernalia, but they were seized under a warrant issued by a United States Commissioner under the Wagering Tax Act, under a contention that the defendant had not registered as a gambler.
Was this man a merchant or distributor of any kind?
No, sir, was not. There was no claim of any distributorship. He was an individual in his own home. The state, of course, alleged and contended that he had a record for gambling in the past and that federal agents and state agents were going in for that purpose, that they had probable cause, one of the contentions in the affidavit being that he had not registered as a gambler and paid his tax, which, of course, since then in Grosso and Machete, this case has...
And the prosecution and the actual trial for possession of these films, was there any effort to reduce proof that the possession of the films was for the purpose of sale?
No, sir.
It was just naked possession of the film.
This is the...
No, there was one other point. There were biscuits in the kitchen.
This was brought up in the brief to this court, that there were biscuits being ready to put in the stove, that there were well-dressed people who came to the house, that this man was a bachelor and his girlfriend had come there, and that the officers had turned them away. They said that the table was set for 8 people, looked like they were fixing to have supper, getting ready to have supper, and for this reason they said that apparently he was going to have a party. This is now the contention raised by the state. But I want to call the court's attention to this.